Hello, this is Greta.
Hi, Greta.
Hi.
We've just opened the...
So Greta, you can see that Jane is having some internet issues. So if she pops out, we may have to you may have to just pick up the mic for her and do the intros, if that's okay.
Okay.
Is it still happening now?
Yeah.
Oh, it's just said it again. I can't get closer to the internet. Oh, you're back. So we've got 26 participants. We're just waiting for a few moments. Should we just give it a minute or more? We're at 30 at the moment.
Might be more appropriate.
Yeah. Okay, so shall we get going? Hopefully my internet will hold out. Hello. And on behalf of myself, Jane Hinton from Hunton Andrews KURTH, and my co-chair, Greta Moy,
It sounds like Jane has lost connectivity. I'll pick up from there. So as Jane noted, I am the co-chair. Hi, Jane. With Jane, and on behalf of us and our real estate finance subsection, we're proud to present to you this wonderful presentation on the LIBOR transition. From Hunton, we have great speakers of Amy Williams, Joe Bonanno, and Kim McLeod. And here is the slides popping up.
Okay.
And I think if Jane doesn't have anything else to add, we'll just jump right in and get started.
Okay, great.
I was going to just say, Amy, if you can hear me, potentially if you could just talk through the polling question and then talking about Q&A at the end.
That's right. So we do hear you, Jane. This is Amy Williams, and we're delighted to be here. I wish that we could be with you in actual person, but this is the next best thing. And we won't be able, your mics have been muted for this program, but there is the opportunity on the slideshow to present questions. There's a Q&A button at the bottom of your screen. In addition, we are going to be doing some polling slides. And when we get to that in just a moment, you're going to have the opportunity using your smartphone to send in your answers. I'll show you in just a moment how you do that. Again, I'm Amy McDaniel Williams, a partner in structured finance at Hunton. With me today are Kim McLeod, who's a partner in corporate finance and real estate, and Joe Bonanno in capital markets. Joe is our chair of our derivatives group, so he's going to be really helpful in that arena. So with that, I just want to start with our first polling question. To get started, what you do is go onto your smartphone and text the word Amy Williams 916. You see it on the screen here, and you text that to 22333. So you're sending a text to 22333 and the text is Amy Williams 916. I'll just give you a minute to do that. Once you log on that way, you'll have the opportunity to answer our first polling question. We're curious to know our audience, in what context do you typically encounter LIBOR? You can answer more than one here. If you encounter it in the context of bilateral contracts, maybe you see it in securities, syndicated club loans. Some folks work with treasury groups and see LIBOR in different kinds of cash management products. You may have clients who have intercompany loans that use LIBOR. You may deal in interest rate swaps or other derivatives. So if you'll just take a moment and pick as many of these items where you might encounter LIBOR. So it's interesting here. It looks like most of the audience, there comes some derivatives. Most of the audience seems to be encountering LIBOR in probably traditional credit agreements, perhaps repos. It looks like we have a question there. Kim, can you help me by telling me what the question is that we've received? You see that?
Oh, it says hello.
Yes, hello. Hello.
Thank you, Michael.
Great. So, as we go through, if you do have Q&A, we may pick them up as we go along, or if not, we'll pick them up at the end. All right, this is really helpful to see that most of our audience are derivatives, and there may be some overlap of folks there. We're going to be talking today about some of the recent developments and things that are coming up in terms of LIBOR transition. But before we got there, I thought it might be helpful just to level set and make sure everybody knows what we're talking about and why it's so important. LIBOR, the London Interbank Offering Rate, very commonly used. In fact, for US dollar LIBOR, let's just talk about what it is. It's an offered rate. It's a rate at which banks say that they can borrow money. And it's calculated in a way where banks are asked, what's the rate at which you can borrow money? And then there's sort of a throwing out the highest and lowest and averaging what's left. And it all sounds very scientific. So if you went back in time, you might think to yourself, well, what could go wrong with such a system? Well, if you were around I guess around 2010, and so you'll know that something really bad went wrong with this system. I love this picture because it makes me think of one of the problems when the scandal broke. Basically, there were people who were reporting these numbers in, and they began to manipulate the numbers so that they could make money for their own institutions, for their own profit centers in their institutions, and basically so they could get bigger bonuses. In one of the texts that came out later, someone asked, can you do this for me? Can you manipulate this? Yes. And he said, done. For you, big boy, there'll be a bottle of Bollinger waiting for you. And that's just a signal, I think, a symbol of how bad it got. We had not just one or two people with market manipulation, but it was a systemic problem. We ended up with billions in fines for some very large international banks. There were, in fact, scandal. They transferred the oversight of LIBOR and how it was calculated to a different group of UK regulators, the Financial Conduct Authority, or FCA. We'll be talking a little bit more about that as we come up. But in the end, even though they tried to come up with better regulations, what's happening is as we said before, because banks were sued for submit these LIBOR submissions and subject the institution to liability. And so we're coming to a point where LIBOR submissions are probably going to stop as soon as the regulators permit or don't require banks to provide them anymore. Right now, we believe that the end is going to happen at the end of the year 2021. There had been some thought that might be pushed off for COVID or related reasons. It seems less likely at this point. So we've got a lot of LIBOR-based instruments that are going to transition to something else, or we're going to have a big problem. Let's talk a little bit about how big the problem is. And here, some of you may remember, how big is big?
Plus you can't take them underwater, and if you do, they... Knees.
Yeah, it's big. So globally, there are about 350 trillion worth of financial products linked to LIBOR and other IBORs. You know, LIBOR is the London IBOR. Now, as these numbers get hard to figure out how to really get a grip on. So we put up a comparison of that 350 trillion to global GDP. I will note that this 85 trillion was global GDP prior to the COVID-19 problems that we see. So that's likely lower. But you can just see from the comparison there how large the problem is with LIBOR and its transition and how we need to pay attention. Interestingly, derivatives, people think about derivatives as often hedges for their what we call cash products, you know, their exposures on other instruments. So you might have guessed that derivatives would account for about 50% of LIBOR products, but in reality, they account for about 90% or more. And I think Joe might touch on why that is as we move along. So that's a little bit of background. Now, before we get into more about what's happening now, we're interested in how comfortable you are with your client's level of readiness for the LIBOR transition. Now, you may have more than one client here, so you can either pick a particular client, or you can talk about maybe what is the general comfort or readiness of your clients. Are your clients completely in the dark? Have they heard of this LIBOR, but not sure what to do? Are they just getting started on planning? Are they planning, but they still need your help? Or E, are they interesting? So many of you think that, more than half of you think that your clients don't know about this. And as we go through, we're going to talk about how probably all of your clients are implicated in one way or the other. LIBOR is not just in derivatives. That 10% covers a lot of ground in instruments that your clients may be in and just not be aware of it. Okay, interesting. So looks like nobody thinks their clients are fully aware of the implications and have a plan in motion. So hopefully we'll help you to lay out some of the issues here today. Okay. Kim, if you would at this point, let's just talk a little bit about the players and what's happening now in terms of how we get to a transition for LIBOR.
Sure. So some of the key players that have really focused on LIBOR transition and are really sort of, I guess, running the process, if you will, is, for starters, the Alternative Reference Rate Committee, which is the ARRC, which was an organization that was pulled together by the Federal Reserve and the New York Federal Reserve Bank. It's a group of private market participants that were convened to ensure the successful transition away from LIBOR. Also, I know in the polling, a lot of you said you run into LIBOR most often in bilateral agreements. The Loan Syndication and Trading Association, which is the LSTA, also has been following LIBOR closely, hand in hand with ARRC, on sort of how you deal with LIBOR transition in credit agreements. In the derivatives market, and Joe will get to this in detail, ISDA has probably been out in front, the most out in front on LIBOR issues, ahead of the LSTA, even on the cash market side. All of these organizations have members, and their members have regulators. So there are a number of folks in addition to these organizational players that are involved in LIBOR. And of course, on the government side, like I said, the Fed, the Federal Reserve, and the New York Federal Reserve Bank were the ones who sort of instigated ARRC. So those two government players are very involved. So again, just to hit on ARRC, it was convened originally in November 2014 and charged with identifying an alternate rate to LIBOR that fit the needs of the market and met standards of best practice. ARRC has been charged with developing plans for the adoption of the alternative rate by the end of 2021. And identifying best practices for how this all gets implemented in our contracts. ARRC has selected SOFR, which is the Secured Overnight Financing Rate, and is promoting SOFR as the LIBOR replacement rate, and has worked extensively with ISDA, who again, and Joe will talk about this in a bit, has already started working on its documents and how SOFR will be adopted into derivatives documents. ARRC has a pretty active website. I think you can link to it through the Federal Reserve's webpage. They've listed their objectives for 2020, including finalizing SOFR conventions for new loans, floating rate notes, and securitizations, to develop transitional tools that the industry can use, to revise their recommended fallback language, including adding an opt-in trigger, which we'll talk about waterfalls and hardwired contracts versus amendments and opt-ins in a bit, but that's on ARRC's objectives for this year. They also are to publish student loan and other consumer product fallback language. And ARRC has a lobbying role as well, so lobbying for tax and regulatory rule adoptions. ARRC is also lobbying on the adoption of some legislation in New York that would help address the situation where you've got contracts that are not easily amended, securities contracts, for example, publicly issued notes, where actually they're looking at a legislative fix because amendments are so difficult there. On the LSTA, again, that's the Loan Syndication and Trading Association, their objectives and their role in LIBOR are really to encourage market participants in the credit agreement market to adopt fallbacks into credit agreements to avoid getting to December of 2021 and having everyone look to amend their contracts to identify the replacement rate. LSTA, again, to that end, or I guess operational risk and market freeze-ups and market disruption would undoubtedly come if folks put off for too long actually addressing these issues in their contracts. And the LSTA is really pushing folks hard to begin looking at issuing debt with alternative rates. So looking to reduce and then eliminate reliance on LIBOR well in advance of the end of 2021. Joe will hit on ISDA and ISDA objectives, but similarly, ISDA is sort of laid out its objectives in this process, including how to calculate fallback rates and spread adjustments, having Bloomberg begin to publish indicative rates, which again, Joe can hit on, publishing supplements to the ISDA definitions and the related protocol. For reasons that Joe will hit on, it may ultimately be a lot easier to implement a replacement rate in derivatives agreements than some other financial contracts. And then ISDA is looking to make sure that they're adopting an effective supplement and the related protocol adherence, which is the method by which folks would amend their derivatives contract. As far as what's the likely replacement rate for LIBOR, we touched on this earlier. It's SOFR, which is the secured overnight funding rate. It's an overnight rate and therefore is more volatile than LIBOR, but it's a combination of 3 daily Treasury repo rates. It is large and robust. There are more than $1 million worth of trades at SOFR a day. But we really need, the challenge is developing a tenored SOFR rate because it is a daily rate. So if you think about contracts where you've got 1 week LIBOR, 2 week LIBOR, 1 month LIBOR, 3 month LIBOR, SOFR doesn't really work like that. So one of the challenges will be developing tenored versions of SOFR. And then also the other challenge, SOFR is really a risk-free rate. There's an element of bank credit risk in LIBOR that is not inherent in SOFR. So looking at how you would adjust interest rate margins is something else that folks are working on because it's not apples to apples. You can't just plug SOFR into loan agreements as a substitute for LIBOR, add on the applicable margin and have the economics of that still work out to be the same. So there will be spread adjustments that need to be accounted for as part of the transition. So there are sort of 4 different tenored SOFR rates that we really could be looking to use. The one that the LSTA is pushing, although we should put an asterisk beside it because it doesn't actually exist today in a way that is reliable or robust, but a forward-looking term SOFR rate. So that's basically a forward-looking reference rate that would be derived from SOFR futures trading. That rate is being published, but it is not at sort of the current levels of liquidity. It's not possible to create sort of the robust forward-looking rate that we would need in order to have this comply with, the methodology, the quality, and other principles of, financial benchmarks that are acceptable in the market today. You could also do SOFR compounded in advance, SOFR compounded in arrears, or simple SOFR in arrears, and the methodology and examples of how each of those would be calculated. But I think the takeaway for now is that everyone is pushing forward-looking term SOFR as the replacement benchmark. This next slide actually comes from the LSTA, and I think the big takeaway here is just to show, if you look at the overlay of a forward-looking SOFR versus one that is compounded in arrears, there's very little change between those rates. So this is designed to give some comfort, I think, to folks in embracing a financial metric that might not exist yet, that maybe it's not so scary and not really so volatile after all. So this really just does overlay the rates on each other, so you can sort of see back to July of 2018 how those rates have tracked each other. What are some ways to get to SOFR? I mean, we have to make sure that operationally it works. The LSTA is pushing hard to get to and have it be operational by the third quarter of this year. Again, some of these timelines may shift somewhat based on what's been going on in the world with COVID, but we're trying to get it operationalized by the end of third quarter of 2020. LSTA is pushing new loans that are originated to contain, or all new loans that are originated to contain hardwired fallbacks by, again, the end of the third quarter of 2020. Again, ideally, new loans that were being originated in the market would not solely be reliant on LIBOR starting in late 2020. You all might have seen that the Fed tried to make a push there in the Main Street Lending Program to make that a SOFR program, and then got nervous about how that operationally would work and backed out and said, no, we're going to do LIBOR. So again, some of these goals may be slightly aspirational, but again, pushing folks to start looking at benchmarks other than LIBOR this year. And then ideally, all new loans would remove LIBOR starting in early, the first half of 2021. And I think we go to Joe.
Okay.
I was going to say, it looked like from the polling earlier that not as many people on the audience work with derivatives. So maybe you can start by just talking about the difference in documentation. You know, when you're doing a credit agreement, you get one long agreement typically, and every time you do one, there's a negotiated credit agreement. But it's done differently in the derivatives world, isn't it? Tell us a little bit about how those documents typically work.
It is for ISDA transactions with derivatives, and also for cleared derivatives, primarily cleared swaps. Those transactions are documented, at least in the OTC world, using short forms of ISDA confirmations. Those confirmations are subject to master agreements with schedules and credit support annexes and maybe other annexes attached. But in the confirmations, the parties make their elections, including in a floating rate transaction, which benchmark they wish to apply, and LIBOR is a commonly selected benchmark. But in order to inform the terms of the transactions, the confirmations reference the ISDA definitions. Similarly, for cleared swaps, the swap terms at the clearinghouses, as published by the clearinghouses, also reference ISDA definitions. And it's those definitions that set forth exactly how LIBOR should be calculated. And currently, LIBOR is calculated by reference to a published rate source. And if that rate source is unavailable, then you poll banks, first in the London market, and if that's not availing, then in the New York market, to see whether or not you can come up with a LIBOR figure. But that's it. If you don't come up with a LIBOR figure, then you're dependent upon your credit agreement in the, assuming that your credit agreement has a similar kind of mechanism for falling back to determine what the next rate is going to be. Some credit agreements may say, for instance, that you use the last LIBOR. In the ISDA world, they don't actually say anything, so it's very hard to determine. So
I'm thinking, Joe, if you polled banks, whether in London or in New York, in January of 2022 or February, whenever LIBOR truly dies, they're not going to have much to say to you.
They may not. People are very worried about that. And that is why we are concerned to have a fallback to a new rate, such as the SOFR rate, which is the leading rate to replace US dollar LIBOR, before that time takes effect. And so we're looking to ISDA in the derivatives world to publish a supplement to their ISDA definitions, which say that should ISDA no longer be available, and we'll talk about why it might not be available in a moment, because there are triggers that relate to why it's not available, we are going to use SOFR. And and it's going to describe the SOFR rate that's going to be used. And ISDA is going to publish something that deals with that in two ways. First, it's going to publish a supplement to its definitions so that any new transactions that adopt the ISDA definitions are going to adopt the SOFR fallbacks that are in the supplement. But for legacy transactions, ISDA has announced that it's planning to publish a protocol. Parties to existing contracts can adhere to the protocol online. And if they do, then any contract they have with another online adherent will automatically have the LIBOR fallbacks amended to fall back to SOFR. And that is how we'll deal with new versus legacy transactions.
Has ISDA done anything like this before where, so it sounds like if I'm XYZ financial institution, I can sign up online to be an adherent, and that effectively changes my LIBOR-based derivatives to have the fallback that people are wanting with anybody else out there who has also selected that. That is, I don't have to hire lawyers to go in and amend instrument by instrument thousands and thousands of derivatives that I might have on my books. Is that the idea?
That is exactly the idea. And ISDA has done a number of protocols for a variety of different reasons so that parties can adopt amendments on a collective basis rather than on an individual basis. ISDA has similarly done a protocol most recently that allowed you to amend more than just ISDA contracts, but other kinds of contracts. This is the protocol that's known as the ISDA 2018 U.S. Resolution State Protocol, and it allows parties to amend not just ISDA contract, but all qualified financial contracts, or so-called QFCs, to adopt the language that has been mandated by U.S. bank regulators with regard to global systemically important banking entities, or GSIBs, in the United States, so that there is no longer a full safe harbor from the automatic stay and insolvency, but rather there is a one business day exception where a bank regulator for an insolvent institution can try and find a solvent institution to which to transfer qualified financial contracts. And
so the substance of that is beyond the scope of this presentation, but basically that was a way that these protocols allowed these financial institutions to agree all my derivatives and all my other financial instruments, notes, securities, loans, bilateral loans, syndicated loans, all of them would have this change applied to them with respect to anybody else on the other side who also agreed to that protocol, right?
That's right. And it's relevant for LIBOR purposes because parties have not only derivative agreements between them, but also loans and securities and other kinds of contracts that use LIBOR. And so they worry, how can I amend all those contracts? Will there be a protocol for those contracts like there is for ISDA derivatives? And the answer right now is, although parties are hoping for that kind of solution, ISDA has not yet announced that they would undertake the kind of solution, nor has any other entity such as LSTA or the ARRC or any other trade organization for that matter.
So what you're saying is maybe our clients will be able to use this protocol for their derivatives, but since most of the audience has clients who do bilateral contracts, they need to get started soon on figuring out what to do. Otherwise, everybody will have too much work to do at the end of 2021 getting those things amended, right?
That's right.
Well, what is the kind of timeline for the IBOR fallbacks protocol that's in place right now? Do you?
Well, it looks like we are going to see a supplement and a protocol draft sometime in the second half of 2020. And then usually it takes 3 to 4 months from the publication of the draft to get a final version of the supplement and protocol. In the case of the supplement is effective and can be used by parties, and in the case of the protocol is open for adherence by parties. So I would bet that it is late 2020 or early 2021 before we see an effective supplement and an open protocol.
Okay.
Now, it makes sense also to talk about what it is that the supplement and protocol will say. And this is also relevant to what ARRC has recommended in terms of language for falling back from LIBOR to SOFR, because there needs to be a trigger event that triggers the obligation to fall back to SOFR. And in the case of those trigger events, both ARRC and ISDA have identified a cessation trigger, which is the determination by the administrator of LIBOR or by a regulator that LIBOR no longer will be published. And they also have identified pre-cessation triggers, which is to say that there's a determination by a regulator that LIBOR is no longer a representative rate, that is representative of the true cost of borrowing. And once that trigger has been struck, then we fall back to a SOFR-based rate. Now, ISDA is presently going to fall back to, we are told, a compounded setting rate. And Kim earlier went over the different kinds of rates. ARRC has a waterfall that starts with a term SOFR, which is based upon futures contracts. But as Kim mentioned, we don't have sufficiently robust trading in futures agreements right now to arrive at a term SOFR rate based upon rates being traded in SOFR futures. So ARRC, if we can't fall back to a term SOFR, then says we fall back to a compounded SOFR. And this is the so-called ARRC waterfall that some of you may know from the Hardwired approach in the ARRC recommended language for falling back from LIBOR to SOFR. Additionally, we need to make an adjustment to the spread between the benchmark rate and the rate that that of interest that's going to be paid or that is going to be used for purposes of the derivative payments that are going to be made. And the reason that we need to have an adjustment made to that spread is because SOFR and LIBOR are different rates. For instance, SOFR is a so-called risk-free rate because it is a borrowing rate that is based upon secured financing, and the collateral is U.S. Treasury and other so-called risk-free obligations. Now, although people say that SOFR is a risk-free rate, it is very nearly so, but not quite so. And the reason is that SOFR borrowers are not all government borrowers. But nonetheless, the collateral makes it look like a risk-free rate. LIBOR, on the other hand, entails taking a view of the bank credit risk. Additionally, LIBOR has a maturity component, at least for LIBOR that is more than just overnight LIBOR, such as 1 month and 3 month LIBOR. And usually rates for higher maturity loans are higher than rates for lower maturity loans. And therefore, when you're switching from a LIBOR-based rate, particularly a rate with a term, such as 1 or 3 months, to a SOFR rate, which is an overnight rate, you've got to add to the spread that a borrower has to pay, because the SOFR rate is going to be lower than the LIBOR rate. Even a SOFR overnight rate will be, which is all that exists right now, will be lower than the LIBOR overnight rate because you don't have the bank credit risk associated.
So what you're saying is if you have a client with a bilateral contract that maybe has an interest rate of LIBOR plus, say, 4%, when you fall back to SOFR, you can't say SOFR plus 4% because you won't be collecting as much interest in all likelihood as you would have in the old, with the old benchmark.
So it would be great for the borrowers, but less so for the lenders.
Yeah, just a footnote. Think about all of the potential issues that are going to come up because there are consumer mortgages that are based on LIBOR that may not have good language in them in terms of fallback. Can you go from LIBOR plus 4 for a mortgage to SOFR plus, I don't know, 6, 7, whatever it might be, or are you going to get sued? That's part of what we're going to see coming soon. But anyway, Joe, I interrupted you.
No, that's quite all right. So what ISDA and the ARRC have agreed upon, and by the way, both ISDA and ARRC are publishing separate consultations about what their respective constituencies think should be the SOFR rate and how SOFR should be calculated, and separate consultations about what the spread adjustment should be and the like. And they are generally, although they started off having a diverging views among their constituencies, there has more recently been converging views. And ISDA and ARRC have agreed that the way to calculate the spread adjustment is to take a 5-year historical look back at the time that the trigger is struck, and then to take the median spread differential between a LIBOR and SOFR, and that is the amount of basis points or percentage points and change that ought to get added to a SOFR base rate in order to generate a LIBOR equivalent rate. And they're going to do that for SOFR and different LIBORs because you're going to have not only overnight LIBOR, but you're going to have to replace 1 week LIBOR, 1 month LIBOR, 3 month LIBOR, and so on. And so that is how ISDA and ARRC have agreed they're going to do that. And ISDA is right now taking the lead also for publishing the calculational approaches to determining SOFR, and as well as publishing the calculational approaches for determining the spread adjustments. And just recently, together with its vendor Bloomberg, has published a calculational methodology rulebook. This is just in the last week or two, that sets forth the calculation methods for determining SOFR rates and spread adjustments and the like. And it's very interesting because although we have seen SOFR rates published, the Fed started publishing overnight or spot SOFR in April of 2018, and in March of this year started publishing compounded SOFR. We have not yet seen what the 5-year historical median is going to be, and Bloomberg is supposed to start publishing that in the next few months. So although there is a calculational methodology that has been published, we haven't actually seen the figures. Some early research suggests that a spread between 1 month LIBOR and overnight SOFR should be in the neighborhood of 36 or 37 basis points. We'll see what it actually turns out to be on a product by product basis. Also, it's interesting to note that the ARRC conceptions of compounded SOFR and the Federal Reserve Board publications of compounded SOFR differ in one key respect so far, and that is that compounding by the Fed is done only every business day, where compounding by ARRC, according to their methodology, is done every calendar day. And we'll see whether or not those things converge as well.
All right, and here's just another slide on the overall timeline for this. But I wanted to go back to something that we alluded to earlier. Maybe, Kim, you can talk a little bit. We've thrown around these words hardwired. Can you tell us a little what this amendment versus hardwired means, and what does the waterfall mean?
Sure. So it's just the difference between amendment and hardwired is whether or not your document, your credit agreement or other loan agreement, other financial document would require an amendment to actually implement the fallback rate, or whether you have, quote, hardwired into that document, assuming you are entering into it as a new loan, or you've got an amendment pending where you can implement a hardwire. But a hardwire approach just doesn't require a later amendment, so it wouldn't require that amendment that we talked about everyone will be rushing to do in December of 2021, because you have already hardwired into the document what happens when LIBOR ceases to be available. And when you talk about
why wouldn't everybody just hardwire into their documents that call for LIBOR that the fallback will be term SOFR? Sounds like that's what everybody thinks is going to be the new thing.
Well, I think that's what we think is going to be the new thing, but since it's not operational yet, and we can't, it's not really meeting the standard yet of what we would use as a true financial benchmark. I think there's some fear of just dropping that in, substituting A for B. What the waterfall approach does is sort of walk you through basically in the section of your contract, a analysis of when is LIBOR no longer available as defined in the contract, when it's no longer being published, or as Joe said, when it's no longer sort of viewed as a viable metric in the sense it's not adequately compensating people for their risks. But when is LIBOR no longer available? And once you have that trigger of LIBOR no longer being available, what happens next? So to what rate do I then fall back, and what spread adjustment do I use to make the replacement rate more comparable to LIBOR? If you look at the ARRC language, hardwired fallback language, there is a waterfall of SOFR rates that starts with forward-looking term SOFR and then goes through the other, and Joe, you might remember the order that it goes in after that, but it basically says if forward-looking term SOFR isn't available, then we go to the other calculation of SOFR, and then so you can sort of waterfall through what may be available. But again, the idea is to have something that is self-executing in a credit agreement as opposed to having to go out and amend it at a time when lots of folks will be amending contracts. I mean, one thing I talk to, I represent a lot of borrowers. One thing I talk to a lot of treasurers and CFOs about is you may not be that worried about, the execution risk of amending your, 10 contracts that you have that have LIBOR-based interest rates in them, but you're just one of JP Morgan or Bank of America or name your favorite bank's customers. And so they're going to be, hundreds of thousands of contracts that have to be amended, not just your 10, and those will all have to be, accomplished by the end of 2021.
Are you starting to see some of those large banks or regional banks or any lenders include hardwired waterfall fallbacks in credit agreements?
I have in the last few weeks. I know we gave this presentation to some folks at HUNTON last week who said, I think in the CMBS market, maybe this has been going on longer, but I would say in my world, the credit agreement world, definitely starting to see folks move towards the ARRC hardwired approach.
When the ARRC recommended language originally came out, the results of the waterfall and how different SOFR rates set forth in the waterfall were going to be calculated were not as clear as those results are now. And so originally people preferred the amendment approach in order to keep flexible, which is to say that when a trigger occurs, then there is going to be an amendment that is specified by the lender or the agent for the lenders in consultation with the borrower, and then the agent or the lender will adopt whatever it is that is going to be adopted as the fallback, rather than a specified hardwired approach. But now that the items in the waterfall and how they're going to be calculated, including the spread adjustments, are becoming more and more certain, people have been deciding that the waterfall approach is a better approach than the amendment approach because it avoids the need to do future amendments. And so we're starting to see the waterfall approach included in more and more agreements more recently, as Kim mentioned. And as she stated, the waterfall starts with term SOFR, but if term SOFR is not available, we move down to compounded SOFR. That should be available, but if it's not available, then we move down to an ARRC recommended fallback. If that's not available, then it is the recommended fallback rate. And then if finally that's not available, then we move down to a rate that is designated by the lender or an agent or some other so-called designated transaction representative. And that is why they call it a waterfall, is because it talks about it's this rate, but if that's not available, then the next rate. If that's not available, the next one, and so on.
And some of those you mentioned are whatever would be recommended by ARRC or ISDA at that time. So that could change, presumably, going forward as we get more information, I would think.
It could, but it's starting to become clearer what it is that each of them is going to recommend, and it's becoming clearer that they're going to be recommending approximately the same things, if not exactly the same things. And also, when there was divergence, people were worried about whether or not they were going to be able to hedge cash instruments such as loans in the derivatives markets if the lending market and the derivatives market used different rates or different calculation methods for adjustments and the like. However, because there recently has been convergence, and also because of the charts that you showed earlier, that there wasn't too much difference between the different rates that could be adopted, people have stopped worrying so much about whether or not you could hedge a cash product in the derivatives market, and about whether and the extent to which there might be so-called basis risk as a result of differences in the rates that might be used in one market versus the other.
We actually have a question from the audience who asks, what if the contract in question does not state the index that the loans will be pegged to? Presumably it says LIBOR, but it doesn't have a fallback in it. And I think the viewer is thinking, what if, you know, we come to the end of 2021, there is no LIBOR and there's just no answer in the document. That might lead to one or more of the risks that are on this slide right now. What are your thoughts about that, Joe?
Well, it seems that there is at least a significant likelihood that the parties would need to amend that document in order to provide a LIBOR fallback, and presumably they're going to want to fall back to a SOFR-based rate. The party who has the greatest interest in this, which I presume would be the lender, assuming that it's a credit facility type of agreement, would probably do well to approach the borrower and negotiate that amendment, or at least set the ball in motion for negotiating that amendment.
Here's a question for you. What if it's not a bilateral contract, but it's a security?
It's a more difficult question if it's a security, because it's difficult to reach and gain the consent of investors in securities for the purposes of changing their rates. And sometimes there is not a good solution to doing that because it's difficult to identify the investors. Other times the securities may not be widely held, the investors may be known. But I think that in the securitization world, for instance, floating rate note world, there are very significant concerns about whether or not it is possible to go out and make LIBOR fallback amendments so as to be able to fall back to SOFR when you can't gain the consent of investors to doing that, particularly where the governing instrument for those securities has a provision that says you can't make amendments that affect the timing or amount of payments that investors receive on their securities without the consent of each and every investor.
Yeah, but on the other hand, the investors didn't expect to go to no interest or fixed rate interest or something. Kim?
But that's the reason why I think there's talk about trying to attack that through legislation in New York, since many securities and notes offering documents are governed by New York law, hoping that, you know, there could be a legislative fix to that very issue so folks don't end up in a standoff where you've got a contract that is for all practical purposes, you know, impossible to amend to address that very issue.
And in fact, ARRC proposed that legislation back in March. And although people are hopeful about it, it's got, I think, some things that lead to concern. For instance, the text of the legislation doesn't solve for all the contractual impediments to amending to create a SOFR fallback that we just discussed, including the need for investor consents. Additionally, the protection against litigation related to the SOFR fallback is not complete, and the prospects for passage of the legislation are not clear. So I think the people who've analyzed this legislation, although hopeful about it, are not necessarily confident that they're going to be able to rely upon it, at least not for all purposes.
This slide talks about tax and accounting risks. Joe, what are you hearing from clients about how the transition from LIBOR to SOFR might hit them on their accounting books or their tax books?
Well, people are worried about tax and accounting issues for a variety of reasons. On the tax side of the world, they're worried, will an amendment to create a SOFR fallback result in a gain or loss on sale of the original contract and the establishment of a new contract? If an establishment of a new contract, will that contract continue to be a hedge, or will it not be a hedge? And the significance there is that derivatives that are not hedges result in capital gain or loss instead of ordinary income and expense for derivatives that are hedges. There are other tax issues as well. For instance, you're not supposed to change the rate of interest for a REMIC regular interest. And so there could be an adverse REMIC event if you do a SOFR amendment. Additionally, original issue discount calculation.
Is the IRS going to come to the rescue on any of this?
Well, the tax rules were proposed back in October and published in the Federal Register to deal with that. The rules have not been adopted, and there have been some comments on the rules, but people are hoping that the IRS will come to the rescue and finalize those rules with the appropriate changes. The accounting issues are similar. Back in February of 2020, there was an accounting standards update from the Financial Accounting Standards Board that basically provided a guidance that said that if you undertake SOFR amendments in a certain way, that you will not have these similar kinds of issues for generally accepted accounting principle purposes. And therefore you should be in good shape in that regard. We're still waiting for finalization of international accounting standards in these regards, and there may be more from the FASB on accounting in the U.S. as well, but we're at least a little bit ahead on accounting right now than we are on tax. There are regulatory risks too, because at least in the derivatives world, people worry about whether they amend LIBOR contracts to provide for SOFR fallbacks. Their legacy contracts are going to still be treated as regular legacy contracts, or whether or not they're going to be regulated as new contracts for purposes of clearing requirements, margin requirements, and other regulatory compliance purposes. And we're still waiting for some guidance from the CFTC on that, as well as bank regulators that take an interest in regulating derivatives that banks have entered into. And there was an ARRC letter to the regulators that was done a couple of years ago now, and the regulators still have not responded to that, interestingly enough.
What a mess. Well, I guess if there's any words to the wise, it would be to talk to your clients about what have they done about LIBOR transition. To the extent clients are regulated institutions, their regulators are going to be putting pressure on them to have a plan in place for what to do with respect to these instruments. And as Kim mentioned, if a client says, well, I'm not worried about this, I only have a handful of these, they should think about what are the banks on the other side doing and try to get in the queue to have this solved. Otherwise, they may be ignored at the time that this comes to pass.
I think too, Amy, encouraging clients to do an inventory of their documentation to be sure it's not just 5 or 6, because I think and I'm part of a group, the Association of Financial Professionals, that is sort of coming up with a roadmap for treasurers, because I think once people start to dig in and look at, oh, I've got a credit agreement, I have this LC agreement, I have these capital leases, I have these intercompany loans that are tied to, my cost of funds under my credit agreement. The hole is a little bit deeper once people start looking. So starting with that inventory and sort of getting your arms around what you got is really the best steps. And then you can think about what's next.
That's exactly right. ARRC has published some recommendations about the kinds of internal steps that parties, corporate entities, banks, and others should undertake in order to prepare for SOFR and for the end of LIBOR. You'll see that most of the preparations that entities that are actually engaging in preparations right now are doing are internal, because we still don't have final SOFR rates that have been published by ISDA and others to fall back to, although we do have the hardwired waterfall that describe them generally. But until we get something a little bit more definite, most of the preparations are going to be internal, and you're not going to see entities, for the most part, going out externally to parties outside their organizations and saying what they're going to do about SOFR. You know, one exception there is that Fannie and Freddie have published statements saying that they are going to require ARRC fallbacks for LIBOR loans beginning in June of 2020, and they're not going to accept any more LIBOR loan deliveries after 2020, nor are they going to accept LIBOR MBS pools issued after December 1st, 2019.
They're signaling that it's coming to an end.
Yeah, right. That's telling us it's coming to an end, at least in the residential mortgage market. The Fannie and Freddie's announcements about the commercial mortgage market have not been quite as specific, but they have said that they are going to be making those kinds of announcements soon. So we're looking forward to seeing those.
Well, Jane, I don't know if there's anything you'd like to say to cap this off, but we have been really thankful to be invited to join you and Greta here and the rest of your committee.
Right. No, thank you very much, Amy, Kim, and Joe. I'm sorry about the internet issues at the beginning. I think that was good. I don't know if anybody else has any questions. No one else has put anything.
Yeah, I don't see any on the Q&A. So, Greta,
yeah, it looks like we lost Jane again, but as she was saying, I don't think that there were any other questions, but last call, if there are any other questions, please put them in the Q&A, and otherwise, you know, a big thank you to our presenters. It was a very informative presentation, and we appreciate you putting in the time and effort to put this on for us.
You're welcome.
Happy to.
You're welcome.
Okay, well, it looks like no other questions, so I think that we will wrap this up. Thank you, everyone. And oh, Jane, go ahead.
No, I was just going to say thank you for stepping in there.
Thanks. All right, bye-bye.
Bye. Thank you.